Good evening. This is Making the Case. I'm Yodit Tewolde. Today in Minnesota, a former high-ranking Minneapolis Police Department training commander returned to the stand and testified that the actions of three former officers did not align with department standards. Those officers, Tou Thao, Thomas Lane, and Jay Kueng, face federal civil rights charges for failing to provide medical aid to George Floyd. Tou Thao and Kueng are also charged with failing to intervene against Derek Chauvin's use of unreasonable force as he kneeled on Floyd's neck for more than 9 minutes. Joining me to talk about day 5 of trial and a look ahead to what we can expect next week, my legal experts Paul Henderson, veteran prosecutor and BNC legal contributor, and criminal defense attorney Brian Watkins. Thank you guys for joining me. Let's talk about strategy, okay? Jurors spent a full day listening to detailed testimony about everything from training techniques and descriptions of the different types of force to how many hours a day new officers train in the academy and how many pages are in the training manual. Paul, what is the prosecution trying to convey to the jury?
Well, the whole point of that is to make sure that they knew and understood that these are trained professionals, meaning they didn't just happen to come across this incident and not know what to do. They knew step by step what was happening, what was unfolding, what the police action was taking upon an individual, that individual being George Floyd. More importantly, they knew and understood the effect of working collectively and collaboratively was having on the crowd and the audience. And remember, the crowd and the audience, the bystanders, are the reasonable people that were intervening, that were interjecting, that were saying that you can't win, that were saying, like, stop this, that were saying, like, you need to do something. And their training made them aware and conscious of what people were saying, and their training made them conscious and aware of what was happening to George Floyd. That's why we're having this excruciating detail that's page by page of what use of force training is, and not ironically to me, is observing and wondering and knowing that the implication of this is that the use of force policies still haven't been reformed, not just in this jurisdiction, but in many others. But that's the whole point of we're putting that information and that evidence in this way for this trial to show the jury that these defendants knew what the use of force was that was being exerted upon George Floyd, and that they also knew what their effect cumulatively was in being in uniform, acting in concert with other officers at the same time that prevented anyone or anything else from being done to intervene. That's the point, and that's what they hope will lead them to guilt.
They hope they can convey that to the jury. Brian, is there a danger that this could be information overload? I mean, what are your thoughts?
Well, no, it's not necessarily information overload. I think the prosecution could have a real uphill battle because you have to understand something. They were following their training. Their training officer was the guy doing it. The training officer was Derek Chauvin. So when you're following your training officer, you are following your training. The officer on scene would trump anything that you read in the manual because the manual cannot address any, actual event. The manual addresses generalities, but of course you can't read a book to teach you how to fight. And when you get into an actual fight, everything is different. So clearly their defense is going to be, we were following our training. Derek Chauvin's our training officer. He was the lead guy. We were following him. And so, the fact that they want to rely on the fact that there may be a sentence somewhere in a manual that may be something different, I guarantee you that sentence in the manual is not going to apply directly to a situation like this. But of course, manuals can't address every type of possible situation that you're going to encounter as a police officer.
Interesting. All right. Well, the prosecution called some of the same witnesses. Paul, do you want to reply to that?
I did. Thank you so much. Okay, so part of what I think the approach is from prosecution, and I think they contemplated that, and that's why they began when they put on their evidence talking about that they wanted this jury to hold these men and these defendants accountable for choosing to do nothing and watching a man die. And that speaks to, beyond just the training, the choosing to do nothing alludes to the duty that they all had acting collectively on how they handled and managed someone that was in their custody. Now, that's a real legal obligation that was breached and violated that prosecution is arguing. And then secondarily, watching a man die, that's a secondary duty that prosecution is alluding to, talking about having public safety for anyone, including a suspect, that they also failed to protect, preserve, and to defend that individual that was being killed in front of them. And so that's how we get beyond just the failure in training, I believe, and what prosecution is going to have to argue. But that's exactly why they started off with that. And I think that they're weaving in the evidence and leaving the plot and the lines of bread along towards getting to a guilty plea to go beyond just a training failure that I think is obviously going to be one of the defense tactics that they're going to raise in this case. So I just wanted to make that point. Thank you.
No, of course. Now let's talk about some of the prosecution witnesses that are being called. There's some of the same ones that testified in Derek Chauvin's state trial, including former MPD training commander Katie Blackwell. The defense made a clear distinction in their opening statements that Chauvin was the officer calling the shots on the day in question, that he was superior to the three officers on trial by way of experience and training. But when the government asked Blackwell today about May 25th, 2020, she testified that technically officers Lane and King were in charge because they were the first to arrive on scene. Paul, I got to come back to you because you deal with police accountability and training every day. Explain to viewers how protocol in this respect works. I mean, how do you have junior officers on their 6th or 7th day of training, yet they're the ones in charge?
Yeah, and so if they are the ones that were the first to arrive, there is an obligation and a duty for them to share information with the other officers and to tell them what's going on accurately. Otherwise, people could get hurt, including other officers. And so that's the duty that they're alluding to when they're outlining who arrived first and who shared what information. Coincidentally, that's going to be relevant later on when we start focusing on the ambulance and the medical care that was given or not given to George Floyd in terms of who told information to the ambulance or any emergency care workers about George Floyd's condition. And the answer to that is that no one did. And that's going to be the tricky part for defendant Lane that is allegedly going to take the stand, because he's going to have to address that. And I think that's a very difficult question. At some point, did you have an obligation, knowing what you knew, even if you weren't the one that exerted the force that killed George Floyd, did you have a duty to share that with the people that were there to help George Floyd and render medical assistance? And everyone was silent in that regard, and none of them went out of their way to explain what specifically had happened to George Floyd or to describe his actual medical condition that they were all present for and had viewed and witnessed. And so that's a real issue, but that's also why there's an obligation to communicate. That's a separate thing and a different reason that a jury can find that these defendants are guilty for not saying something beyond just not doing something. That's why they're focusing on it and talking about who arrived first and what was said or what was not said, being corroborated by the body-worn cameras that's being shown in this case again and again, as we expected, just like from the first case. That's the significance.
Well, Blackwell made two statements that spoke directly and succinctly to the charges these officers face. When the government asked, would any restraint be consistent with policy if Floyd was unconscious? Blackwell said no. When questioned about what should happen once it's clear Floyd had no pulse, she said, quote, now they must perform medical aid. Brian, of all three defendants, Lane was the only one who actually called the ambulance to the scene and the only one to go inside the ambulance to help paramedics try and revive Floyd. That was what the paramedic who arrived first on scene testified to. So clearly, Blackwell's testimony is damning for King and Thao, but could the jury find Lane's attempts enough to acquit him?
Possibly. One of the things is, we're kind of Monday morning quarterback in this because we know that George Floyd ended up passing away. However, when you're on the scene and you do hear him talking, the question is were they close in proximity enough to know that, hey, this is getting serious and he could die? A lot of trust went into this. Basically, those other officers are going to say, I trusted Derek Chauvin, my training officer, who was the person who was directly handling George Floyd to monitor his condition. And I trusted him to say if it was getting bad that he would stop and do anything. I technically wasn't monitoring his health while this was going on. I was relying on my fellow officer, Derek Chauvin, who messed up. So I think they're going to try to shift, of course, a lot of blame on the person who's already been convicted, the guilty party here, Derek Chauvin.
I want to get reaction from both of you to an exchange that Jay King's defense attorney had with Katie Blackwell during cross-examination. When discussing the signature page on a training manual, Thomas Plunkett said, quote, the fact that you sign a page Acknowledge receipt of the manual and put it in your permanent record doesn't mean you know the manual, correct? And Blackwell said they're supposed to know it. Paul, we're all guilty of signing documents, acknowledging we understand all of the fine print when we didn't actually read it. But we're talking about police officers responsible for protecting the lives of others. So the fine print here is important. I mean, we're talking about a training manual. So was this smart on the part of the attorney to essentially call out his client for not reading his manual?
I don't think so, and I'll tell you why. There's a distinction and a difference between signing off a liability of waivers when you're joining a gym versus signing off your training for use of lethal force when you're in the police department. And that, to me, opens the door for an analogy like that to be made to the jury so that they know and understand the distinction. Because what we don't want is for public safety officers. What we don't want is for law enforcement agents to be signing off cavalierly so that we are at risk when they are empowered to use lethal force. And in the context of this case specifically, where lethal force was used and someone died, that is not an excuse that, well, there was some training and I just signed it, but I wasn't paying attention. That's not going to fly. And I don't think that that's going to go over very well with this jury. And they didn't score any points and, in fact, may have injured or diminished the credibility of the claims that they're trying to make on behalf of the defendants. So in short answer, no, I don't think it was helpful. No, I don't think it was a good strategy for them. And I do believe it's going to undermine some, at least one of the defenses that they may be able to raise in terms of misunderstanding what happened at the training that they all agreed that they participated in, learned from, and increased their salary and were allowed to continue with their employment because they attended it. That's a big deal. You don't get to give that short shrift, and you certainly don't get to sideswipe it to diminish your liability, your exposure, or your responsibility in defining public safety and specifically the health and wellness of anyone, including suspects on the street. So not very smart, in my opinion.
Brian, give me your take on this. Smart strategy or on the part of the defense?
I think it is a smart strategy, and I'll tell you why. You can't hold someone to every sentence in a manual, okay? A manual speaks in generalities. It cannot address a fluid situation when you're actually dealing with a suspect. So to say that there's a sentence in there that says they should have done something different is not going to make them criminally liable because they failed to do that. They say, look right here, it says right here, page 10, line 4, it says you should have done this to George Floyd. How come you didn't do it? Therefore, you're guilty. I mean, a manual is just that. It's a manual. It gives you guidance, but it doesn't teach you step by step how to deal in every fluid moving situation when you're dealing with a suspect. And so I think the prosecution's put a lot of weight on this manual, but like I said, when you actually get out in the field and start doing things, the manual kind of goes out of the window and you fall back on your training and your training officer, who was Derek Chauvin, who was there, and he's the guilty guy. So if I'm the defense attorney in this case, I'm putting all the blame on Derek Chauvin.
All right, Paul Henderson, Brian Watkins, thank you so much for your time tonight and the insight.